Boris, I know that people tend to do like balls and strikes here in terms of where your ideology is, but I look at it as an attorney, and from the beginning of this, I've been extremely concerned about the constitutionality of this search. Now, we don't know a lot of facts, but I've been on a lot of murder crime scenes where I see over anxious and understandably well-meaning police officers in a heightened situation. They're not thinking it through. Maybe they're not in contact with their prosecutors or lawyers, and it's natural and instinct to just kind of open the bag and take a look-see to see what's inside. It happens all the time. And the defense is essentially saying here, the Constitution requires that every search be done pursuant to a warrant, a judicial warrant. And there are some exceptions to that warrant requirement. And the defense is saying there are no exceptions here. For example, if somebody consents to having the backpack looked into, then that's an exception to the warrant requirement. So I hope that I'm not going to hear that they just grabbed it. They were excited. They didn't have probable cause. They weren't in fear. They weren't in danger. He was secured, and they just looked inside and then afterwards got the warrant. In New York state law, that may be a problem. You have an easier chance under federal search and seizure law.
It sounds like you think that if this evidence is tossed, the state is going to have a hard time finding him guilty.
Wow, this would be a massive blow to the government. But then again, let's keep in mind here, we have both state prosecutions and federal prosecutions, and what may be suppressed in state court, again, federal court's more accommodating the prosecutors. But the evidence in that backpack, even though you don't need motive to prove a homicide case, shows premeditation. It's got the weapon. The weapon is connected to the victim in the case. It shows a cold, calculated, premeditated murder. It is the lock that any prosecutor wants. Otherwise, they got to go without that evidence on a circumstantial case that's much weaker. In that case, it's going to be interesting to see, really, to be honest with you, Boris, when the law enforcement authorities get together, there's got to be a discussion. Is it better to prosecute them federally first or better to prosecute them state-wise? Now, if there's a suppression of the evidence in state court, you can bet the federal case is going to take precedent. So the issue in this case is going to be, and we just don't know the facts yet, was he in fact under the reasonable belief that he was not free to leave, and was he asked the question without being given his Miranda warnings? And if that happens, then any statements that he made up until the time he gave his Miranda warnings is subject to being suppressed by the court. But again, in this particular case, if I were a prosecutor and things were on the line, I'd rather lose on the Miranda side of the case and make sure I win on the search and seizure side, because that's where the case is going to be won by prosecutors. What's in that backpack?